Good afternoon, and thank you for joining us. I'm Robert Pondiscio, a senior fellow here at the American Enterprise Institute and the James Q. Wilson Program in K-12 Education Studies. It's a pleasure to welcome you here today for today's event marking the 100th anniversary of Pierce v. Society of Sisters, a Supreme Court decision whose central insight remains as urgent today as it was in 1925, that the child is not the mere creature of the state. That phrase, stirring, memorable, often quoted, has become a kind of rallying cry for parents who feel sidelined in today's debates over curriculum, school policy, and educational priorities. But it's worth remembering that it was first uttered not in a culture war skirmish, but in a unanimous ruling that struck down a state law requiring all children to attend public schools. In effect, Oregon tried to outlaw private and parochial education, and the Supreme Court said no, unanimously. I wrote about this 3 years ago in a cover story for Commentary magazine titled "School Children Are Not Mere Creatures of the State." The timing was no coincidence. The pandemic had thrown open the classroom doors. Metaphorically speaking, the classroom doors, of course, were closed. Parents had a rare and sometimes uncomfortable view into what their children were learning or not learning during remote instruction, and some didn't like what they saw. But what was perhaps even more shocking to many parents was the response they received when they tried to engage. In one New York school district, parents were warned not to, quote, listen in on their school district's remote lessons. In Washington, D.C., middle schoolers were asked to sign anti-racism pledges with their parents' signatures. In Loudoun County, Virginia, parents were doxxed online for speaking out against school board policies. In San Antonio, Texas, a mother who raised concerns about the sexual content in a book was banned from her child's school. And increasingly, ominously, we've seen school districts adopt policies that affirm a student's change in gender identity at school using a different name or pronoun without notifying parents or even explicitly instructing staff to conceal that information from them. These are not small things. These are life-altering decisions about how a child understands himself or herself. That a school would insert itself in between a child and a parent on such intimate, formative matters, often deliberately and as a matter of policy, is a sign of just how far the shift has gone. So if Pierce said that the child is not the mere creature of the state and its public school districts increasingly seem emboldened to say, oh yeah, let's see about that. Whether through policy, curriculum, or bureaucratic design, the institutions of public education are asserting themselves more aggressively in areas once reserved for family, culture, and conscience. And that takes us back to Pierce. The court's ruling did not just protect religious schools from discriminatory laws, it affirmed a foundational truth, that the family, not the state, is the first and most important institution in a child's life. That while the state may compel school attendance, it may not compel conformity in thought, in belief, or pedagogy. That children do not belong to the state. In our current context, Pierce is often invoked in defense of school choice, and rightly so, but it also forces us to ask broader questions. What happens when the education system itself, public or otherwise, begins to treat parents as adversaries? What happens when the default posture of schools is not partnership, but gatekeeping? This afternoon's first panel will examine the legal legacy of Pierce, how its reasoning has shaped the past century of education law, and where its limits might lie in the current moment. But I'm particularly looking forward to the second panel, which I will moderate, featuring parent advocates and homeschooling families. These are people whose work and experiences reflect the unresolved tension between parental authority and institutional power in education. They will help us understand whether Pierce remains a living constitutional principle or merely a noble, neglected phrase carved into case law. 100 years later, the question is not whether Pierce is still on the books, it's whether its spirit survives in our public life, whether parents are still regarded as the primary stewards of their children's upbringing and education, or whether that authority has been ceded quietly and steadily to institutions that no longer trust them. So I thank you all for joining us today. I look forward to a lively and very necessary conversation. There will be two panels today, the first on the law, the second on parenting. And let me introduce now the moderator for our first panel. She will then, in turn, introduce the panelists. Corey Brewer serves as education counsel at the Wisconsin Institute of Law and Liberty. Before joining Will, Corey worked in private practice as a civil litigation attorney. She now focuses on legal and policy issues related to K-12 education. This includes efforts related to public school reform through the Restoring American Education Project and expansion of school choice by empowering families with the freedom to choose the best education for their children. Please welcome Corey Brewer.
Thank you very much, Robert. I'm so glad to be here today, and I am going to get right to it and introduce our panelists for the legal panel. These are shortened bios because we have a very impressive group with us here today. First is Luke Berg. Luke is a deputy counsel with the Wisconsin Institute for Law and Liberty, and he litigates cases involving parental rights and a variety of other topics. Before joining Will almost 6 years ago, he served for nearly 4 years at the Wisconsin Department of Justice as a Deputy Solicitor General. Luke has argued 11 cases before the Wisconsin Supreme Court and 6 before the Seventh Circuit. He graduated from the University of Wisconsin-Madison with a Bachelor of Science degree and received his law degree from New York University and served as a law clerk for Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit. He resides in Madison with his wife and 3 boys. Next, we have Kate Anderson. Kate Anderson is senior counsel with Alliance Defending Freedom and director of its Center for Parental Rights. She leads ADF's efforts to ensure schools respect the rights of parents to direct the upbringing, education, and health care of their children. In 2023, she successfully defended parents in Wisconsin, a case on which Will was proud to serve as co-counsel, and her team continues to protect parental rights nationwide. Since joining ADF in 2015, Kate has defended individuals punished for standing by their beliefs and played a key role in 303 Creative, a landmark Supreme Court case on free speech. Her work focuses on parental rights, religious liberty, and freedom of expression. She's also argued that redefining sex to mean gender identity creates legal confusion and results in outcomes that are unfair to women and girls. Prior to ADF, she practiced law in Seattle. She's admitted to practice before the U.S. Supreme Court, several federal district and appellate courts, and the state bars of Arizona and Washington. And our third panelist today is Melissa Moskella. Melissa is professor of the practice in philosophy at the University of Notre Dame McGrath Institute for Church Life. Her work spans the fields of ethics, political philosophy, and law. Her areas of expertise include natural law theory, biomedical ethics, and the family, especially parental rights. She's the author of the books To Whom Do Children Belong? Parental Rights, Civic Education, and Children's Autonomy, and Ethics, Politics, and National Law, Principles for Human Flourishing. She has also published numerous articles in scholarly journals as well as popular media outlets. She's a graduate of Harvard College, earned a licentiate in philosophy from the Pontifical University of the Holy Cross, and received her PhD in political philosophy from Princeton University. Please join me in welcoming our panelists today. All right, I plan to get started today with a question to each of our panelists, and then we'll have a little bit more of a discussion, but I think we will start with Kate. Can you please set the stage for us? What are parental rights? Where do they come from?
Well, parental rights come from the notion that parents are the right ones, to direct the education and upbringing of their kids. We know this to be true, and society and people of all faiths and cultures have long understood that it's the parents' role to raise their kids. That's why the Pierce decision is so important, because there the U.S. Supreme Court wrote that down, that the student or the child is not the mere creature of the state. But what's interesting is in that same sentence, then the court talked about the high duty of parents to raise their kids. So parental rights are always tied to the high duty that parents owe to their children to raise them, to educate them, to make decisions about their health care when they can't make them for themselves. And it's critical that our society recognizes that, just as the Supreme Court said years and years ago. And the Supreme Court has reiterated that over and over again, this principle that parents direct the upbringing and education of their kids. But what has happened since then is that lower courts have cut away at that principle when they put it into practice, especially in the public schools. So we saw a line of cases dealing with curriculum and opting out of curriculum and various school policies, starting really in the 90s and then into the 2000s, that scaled back this understanding of the right. And Pierce started because it was a law that attacked the ability to educate your children through private and particularly Catholic education. And the court there said, no, of course parents have this right to educate their kids in accord with their faith. But as the cases have come on since then, there's been sort of a cabining of Pierce to say that it's really about the parent's choice to choose homeschooling, public school, or private school. But once you leave your child at the schoolhouse gate, you lose all of your rights. And we're seeing the consequences of that. Kids being taught radical ideas about race and gender. Kids as little as kindergarten being told that there are more than two genders. They can't even tie their own shoes, and they're being told they might be born in the wrong body, or that they should have an opinion of somebody else because of the color of their skin. And you saw, as we were talking about just in the introduction to this panel, COVID brought attention to this for parents. And so as you saw these court cases, this history of cutting away at the rights, now you're seeing parents sort of swell up against that, saying, we do believe and really truly feel that we're the ones that need to educate our kids, and we need to come back to that principle. And so I think that's the litigation things that you're seeing today.
Thank you. And now, building on that foundation, the Constitution doesn't explicitly mention parental rights. So Melissa, if you could kind of build on what Kate shared. I know in Dobbs, the court pared back what is called substantive due process, and held that any of those rights had to be deeply rooted in our history and tradition. So just whatever you can do to add to that, what is the historical basis for parental rights?
How many hours do I have? No. So I'll keep it brief, but there's a lot to be said, and I'll preface this by saying I have a couple of law review articles, one published in the Texas Review of Law and Politics last year, I think, and then one coming out any day, sometime this month, in the Notre Dame Law Review and a symposium issue on Pierce that basically gives great details, the detailed version of what I'm going to say very briefly here. So you can find all the citations and all the references and lots more than I will have time to say. But the long and short of it really is that the basic idea of parental rights that Kate talked about, the idea that parents have natural authority over their children that is prior to and independent of the authority of the state. They would have that authority even if there were no state, right? And the state didn't give them that authority. That is the vision of parental rights that we see in American legal history. And even prior to that, in the common law tradition in England, which America then kind of took on at the founding of the nation. So, you know, if you think about our history and tradition and ask, well, what are the rights that are very deeply rooted and very strong and unanimously recognized throughout our history and tradition, the strongest case can be made for parental rights. And especially if you're thinking about interpreting the 14th Amendment and what was the original understanding of that amendment, what did the framers and ratifiers of that amendment and the population at the time kind of have in mind, and did that include parental rights? I think the answer to that is a resounding yes, for many reasons. One is that, you know, during the founding era and certainly at the time of the 14th Amendment's ratification, the idea was that parents had a natural authority, a kind of jurisdiction over their children, and that this was understood to be prior to and independent of the state's jurisdiction over children, such that the state really doesn't have direct control or even direct jurisdiction over children, but that's mediated through the parents, unless the parents are found to be unfit. So the kind of prior step that always needed to be taken when the state wanted to do something to a child was to either get the permission of the parent or prove the parent to be unfit and then intervene directly. And that means that the rights of parents in our tradition are both broad in the sense that they encompass all aspects of a child's upbringing, education, healthcare decisions, custody, of course, and they're also strong, which kind of in contemporary legal standards would be something akin to the strict scrutiny standard, that the state has to show the kind of highest level of interest, and it has to show that when it's infringing on parental rights, that there's no less burdensome way to achieve that interest. And that's what you see happening in court cases throughout the kind of middle of the 19th century and the early 20th century prior to Meyer and Pierce, including court cases about opting kids out of things in the public schools. So, you know, there's a string of 8 really interesting cases that are often not talked about. The first in 1870, so just 2 years after the ratification of the 14th Amendment. So it really gives you a sense of what was, you know, understood at the time to be the rights of parents, including in the public schools. In that case, and these, you know, 7 other cases that were decided at that time, 7 of 8 of those, the parents won the right to opt their children out of subjects in the school that the parents didn't want the children to participate in. Often there wasn't any kind of ideological issue. It was simply, well, my child needs to spend more time on math, and it's not that important for her to take the singing class, and so we don't want her to go to the singing class so that she has time to do these other things. And as I said, the court said, on the basis of common law, that of course parents had this right, because even in the wake of compulsory education laws, the state Supreme Courts made clear that that didn't take away the fact that parents are still the primary educators. And so the court said again and again that parents retain the right to select among the courses offered at the public school, as long as that was compatible with reasonable efficiency and discipline in the schools. And that's why they won again and again and again. And these cases were also, they were part of the brief for the Society of Sisters in Pierce. And so my understanding of Pierce, following Meyer, is that it was implicitly declaring that this understanding of parental rights in these earlier cases and in the broader common law tradition was understood to be part of the liberty protected by the 14th Amendment. And that's what Meyer and Pierce were declaring. And just one last piece of evidence about the fact that this was part of what was understood to be the liberty protected by the 14th Amendment, whether you want that to be in the Due Process Clause or in the Privileges or Immunities Clause. I mean, I'm agnostic on that, but I think it's in there. And I think a further piece of evidence of that is that one of the things that was being discussed and that was driving the need for this amendment to protect, and especially the rights of freed slaves, was the fact that under slavery, the African Americans were not given the right to raise their own children. And that was one of the great violations of the rights of slaves. And they wanted to make sure that those rights would be protected henceforth through the 14th Amendment, among other things, with the rights of freed slaves. So there's a lot of evidence, both from the ratification era of the 14th Amendment and then from the whole history of our nation, that parental rights were understood to be broad and strong, and that's what Pierce affirmed.
Thank you. So now that we know what parental rights are, where they come from, how far they go back, Luke, can you tell us about the current legal landscape? Where are these cases being litigated, and how have they gone?
Yeah, so although Pierce has been around for 100 years, There just hasn't been as much litigation, I think, over parental rights as you might have expected for a case that was 100 years old. And I think that's in part because, in the main, we sort of take this for granted, government has respected parental rights. That has changed recently. And so you've just seen this explosion of parental rights litigation in recent years, and kind of in three main areas that I'll talk about. So the main one, the one that Kate and I have litigated and are very passionate about, is these secret gender transition policies in schools. So schools across the country have adopted these policies that allow minor students, often of any age, to change their name, their pronouns, and bathroom use at school in secret from parents. So no notice to the parents, no consent from the parents, and in some cases, schools will actively conceal this from the parents by altering records, by using one name at school and another when the parents show up, so that the parents can't figure out what is happening at school. So this is happening everywhere. In some cases, parents find out about this months after the fact. There are multiple cases where minor students attempted suicide before the parents even, or the school even told the parents what was happening with their struggle with gender. So by my count, there are now 35 to 40 of these cases around the country, and I may not have a complete count, so there might even be more than that. We have litigated 3 of them in Wisconsin alone, 2 of them with Kate, and Kate and her group have many more around the country. But how have they gone is sort of a mixed bag. I think our case against the Kettle Moraine School District is the only one that's won completely on the merits so far on summary judgment. There's been some wins on preliminary injunction motions. Some of the cases have settled, but more cases have lost than won. Some on the merits, but a lot of the losses have been on ancillary issues. So courts are just sort of avoiding the merits, standing, immunity. This sort of shocks the conscience test. I'm not going to explain that, but there's lots of different ways that courts are kicking these cases without actually reaching the core question of, can schools do this? Can they hide a gender transition from the parents? It is very frustrating because it seems like such a clear and obvious parental rights violation. And it sort of feels like the courts have lost the forest for the trees. If parents come in advance and say, you have this policy that on its face says you're gonna disregard me and hide something from me when this happens with my child, courts are saying, you're too early, you can't sue. And then when it happens to them, no parent's gonna leave their child in the school district for 3 years to litigate the case. So they pull their kids from the school district, and then courts are saying, well, you're too late. So it seems nobody can litigate this. So it's very frustrating. But these cases are not going to go away as long as schools keep doing this. And there are millions of students in the country that are in school districts that have these policies. And those of us who are public interest litigators know it can be hard to find plaintiffs, but nothing makes a more eager plaintiff than a parent whose child is messed with by a bureaucrat. So these cases are just going to keep coming. I think eventually it's going to sort of, it is and will continue to split courts in all sorts of directions. And eventually the Supreme Court's going to have to weigh in. So that's one main category of cases. At the same time, and this is so interesting, sort of the left is bringing parental rights claims against state laws that limit so-called gender-affirming care, puberty blockers, cross-sex hormones, and gender transition surgeries. So these are statewide laws that ban this for minors. And the left is bringing claims saying that's a parental rights violation. We as the parents have the right to direct the medical care of our child, and this interferes with our right to use these procedures. Those cases have actually been more successful in the trial court. Shockingly to me, I think that's a much worse parental rights claim, and we can get into that later. On appeal, those have mostly lost, but that's happening simultaneously, and that just makes this whole topic so interesting because you have the same kind of claim, I do think they're very different, but the same kind of claim being brought at the same time by opposite sides of the political aisle. And then the third one that shouldn't go without mention is Mahmoud, the case currently pending before the Supreme Court. This is an opt-out case. So Montgomery County School District adopted a curriculum that involved a lot of LGBTQ-themed books read to children as young as pre-K. And a lot of parents wanted to opt their children out of these books. And initially, the district agreed to respect that, but then pulled that back and said, we're not going to respect any opt-out. So That claim was not brought as a parental rights claim directly. It's a religious liberty claim, but parental rights is certainly in the background and certainly going to be on the court's mind. And that one's really interesting because it's sort of a one-off. There hasn't been a lot of opt-out claims brought, in part because there was this, 2 decades of losses on challenges to curriculum, attempts to opt out in the lower courts. And so it's interesting that this is the first one the court has taken up, and we're all sort of eagerly waiting to see what the court will say about it.
I have high hopes.
Right, yeah. It very much sounded like the parents were going to win from the argument, but it was clear the court was wrestling with how far opt-out rights are going to go. And I expect something, whether a footnote or an alternate opinion, is going to say something about parental rights. And so very interesting to see what's going to happen with that case.
All right, thank you. And we're going to get into some of those details coming up here and those ongoing cases or cases we're waiting on decisions on. But I want to first get into a little bit more of the why. And Melissa, I'll start with you, but I want to hear from each of you. What is the justification for parental rights? Is it for the parent's sake? Is it for the rights of the child? Why?
I think it's both, and I think you can't separate them. So I think if you were to ask, what is the most fundamental right that a child has? It's the right to be loved and, when possible, raised by his or her own mother and father in an intact family. And that means the right to have decisions made for the child by those who most know and love that child, who have the greatest knowledge of the child, the greatest motivation for the well-being of the child, and the greatest alignment of interests with the child, right? If you just think about which adult has the greatest alignment of interests with a child, it's almost always the child's parents, right? Who is going to have to pick up the pieces if the child does not successfully mature into, a self-sufficient adult? It's going to be the parents who are going to have to deal with that pretty much for the rest of their lives. So the parents have every interest, even selfishly, in making sure that children turn out well and thrive. But of course, it's not just that. It's not even primarily that. The parents are the ones who actually love their children, care about their children, again, more than anybody else in the vast majority of circumstances. So the primary right that a child has is to have those people, the ones who know and love them the most, make decisions on their behalf, and not some state bureaucrat or even a teacher who, teachers can be wonderful and can care for children, but they don't have the historical knowledge of what's happened to that child, throughout the child's whole life. They don't have that same alignment of interests, kind of in terms of the long-term well-being of the child. They don't love the child or know about the child nearly as much as the parents do. So the best way to protect children's rights is to have strong parental rights. But I do think there's a kind of independent reason why parents have rights, or at least one, probably more than one. And that is the fact that parents have this natural and very serious obligation to take care of their children. And it's an obligation that requires making decisions on the children's behalf, because children aren't mature enough to make decisions for themselves. So one of the key things that you have to do to care for a child is to make decisions on the child's behalf. And the ability to fulfill that obligation is actually really important for the parents' well-being, right? Because the way in which we thrive as adults is in large part by conscientiously fulfilling our obligations. And for many people, the most important obligations that they have are their family obligations, their obligations to their children. So there's a basic kind of conscience right that parents have to fulfill their obligations to their children in line with their duties, which in many cases is a religious obligation as well, because many parents see that as a duty that's given to them by God, a trust from God that they are bound to fulfill and that they have to answer for. But also, there's a basic parental right that's distinct because the authority that parents have over their children is by nature, and there's a right that protects that authority from state interference. And I think people who want to just reduce parental rights to children's rights miss the fact that parental rights also protect this distinct authority structure that does not have its origins from the state. And so there's also an argument for parental rights as distinct from children's rights. That's an essential aspect of limited government, an essential aspect of recognizing that the government does not have authority over every aspect of life, that there are pre-existing authority structures, like the family, that have their own rights to make their own decisions relatively independent of state interference. And so protecting those parental rights is a crucial aspect of limited government more generally.
We don't have to go down the line, but I think it's fascinating, that last point you were making, that parental rights are something not that the government gives to parents, but something that parents have independent from the government. And the Constitution only comes in to protect what's already a right given. And so that's an important component here. I also want to pick up on what you said about parents' rights and children's rights being tied inextricably together, because parents do have this high duty to raise their kids, and they can't do that if the government is getting in the way. And so parental rights are critically important to push the government out of the way so that parents can be parents, because they do love their kids and they do know their kids best and are in the best position to know all the factors, all the things, all the influences going on in their kid's life to help that child become a productive adult, be happy and healthy, and make those decisions. And we're seeing in our culture, tying back to what you were talking about, what happens when the government tries to strip away parental rights through taking parents' decision-making or hiding information. And I think the secret social transition cases are a prime example of that. The clients that we represented, talking to the daughter there in Wisconsin, she talks about how damaged she was by being told that her parents were the problem and that they didn't understand her. And she was being told by healthcare professionals, by teachers, by counselors, that it was what was going on with her, what she was struggling with, was because her parents didn't understand her and weren't affirming her. And she finally hit a moment where she realized her parents were the only ones that did care and did want to get to the bottom of it and help her walk through her difficult struggles with gender identity. But you see these kids being damaged when the government tries to separate out and infringe parental rights. And I think that's important here when we're talking about children's interests.
Yeah, I agree with everything both have said, and don't have a lot to add to it. I think it's so important to connect parental duty with the rights. I think when we really talk about parental rights, what we're really talking about is decision-making authority, and it's just so obvious that, a 2-year-old can't make decisions on their own, so someone needs to make those decisions. And as we all know, children don't just appear spontaneously; they're created by a choice of the parents. So naturally, the duty is on the parents. There's just no one else who has a duty to make the decisions for that child. And with that duty comes the authority to make those decisions. And it's annoying that we have to say it because it's so obvious, but it is also helpful.
And it should be obvious to everyone, no matter where they land on the political spectrum, which is something that's frustrating to me, because this is about every parent's right to be able to raise their kids and to guide their kids the way they think is best for that child. It's not a particular viewpoint on how to do that. And when we give away those rights, those are dangerous for everyone.
And courts have analyzed this parent-child relationship too. This is something that they've discussed. So if anyone, Luke, I'll start with you if you want to touch on that. But I'm curious too, how would you respond to the question, don't children have rights too?
I mean, unquestionably, the answer is yes, but rights in what sense? So right not to be harmed, right to life. But what we're talking about, I think, with parental rights is decision-making authority. And nobody thinks that a 2-year-old has decision-making authority. Nobody thinks that a 3-year-old has decision-making authority. So the very point of giving an adult, the parent who knows and loves the child the best, that authority is in part to protect the child's rights. That's part of the point.
Parents protect the children's rights. So you see court cases where parents are coming in on behalf of their kids to protect their rights when they're being violated, which I think is important.
Yeah, and I would just add that, of course, everybody here agrees that there are limits to parental rights to protect basic rights of the child, the bodily integrity of the child, and we'll get to scrutiny, but I think that's going to be crucial in that case for distinguishing things and for recognizing limits, right? But everybody agrees that if parents are proven unfit, now there's a lot that needs to be done to reform the so-called child protection system, which often goes too far in terms of violating due process, treating parents as guilty until proven innocent, and and not the opposite, and so on and so forth. But with those kind of practical things aside, in principle, we all agree that when there's a genuine case of abuse or neglect, then it can be necessary for the state to step in and ensure that the child is properly cared for. But what parental rights protect is the idea that the state can't just say, well, I disagree with you about what's best for your child, and so now I'm going to step in and override the judgments of a fit parent who has not been proven guilty of abuse and neglect.
Thank you. And I do want to get to scrutiny. So Melissa, I'll just follow right back up with you. This is the case that Luke was mentioning in terms of states that have banned so-called gender-affirming care for minors. Challengers of those laws have raised parental rights claims. Is that a legitimate parental rights violation, and why or why not?
So two things. First, I think what's going on with these laws that are banning puberty blockers and gender transition surgeries and cross-sex hormones is that the state is exercising its normal jurisdiction over public health. So the state does this for treatments for adults as well. I mean, if there's a drug that I want that's not allowed by the FDA, I can't get it. And I'm an adult, right? Even if I do my own research and say, look, Canada sells this drug, Europe sells this drug, I'd like it. I think it would help with whatever condition I have. I can't get it. Now, I may be able to get it illegally, but I can't get it legally, right? And the same thing goes with if there's some surgery that I think would be beneficial to me that the state has said no, that's there's no proof that that's good, that's medical quackery, and we're going to outlaw it because it doesn't seem like there's any show of benefit here, or that it doesn't seem that the benefits outweigh the harms, and we're going to outlaw it. As an adult, I have no rights to go to sue and say that I should be allowed to get this medical treatment. And then the same thing goes with parents for their children. If the state has decided these are just dangerous, quote unquote, treatments, they don't even meet the bar to be called medical care, then the parents can't just say, well, because I'm a parent, I get to override the health authority of the state. But a second thing I would note is that there's a long history of states, even for adults, outlawing interventions that involve permanent and irreversible loss of bodily function. So basically laws outlawing mutilations. Again, apart from state-approved medical treatments, right? But it's the state that decides what's the difference between a mutilation and an approved medical treatment, and that it decides that in the adult context. But that's even stronger in the child context, where the state has often said, okay, yes, parents have rights to make medical decisions on behalf of their children, but there are some limits there, and those limits are typically in cases where the child's life itself is at stake. So you have cases like Jehovah's Witnesses that are opposed to blood transfusions, and if it's deemed that a blood transfusion is absolutely necessary to save a child's life, the state will typically override the parent's objection there. And I think that's reasonable because life itself is at stake. But there are other things that have been non-controversial, even in the DC area, as I understand it. There's been a long-standing law on the books prohibiting parents from doing anything that would result in the sterilization of their children. And that has actually prevented DC medical providers from doing a lot of these things. But that makes sense, right? This is something that a child, even a teenager, doesn't have the maturity to recognize what is happening if they're losing the ability to be able to have a child, or at least have a child naturally. And no parent, I think, can make that decision on behalf of their child. So it's a reasonable limit, given all the evidence that we have that these treatments have many harms, many irreversible effects, and very few, if any, proven benefits.
To my mind, and this has been helpful for thinking about these different topics, there are kind of two categories of parental rights cases. One of them is sort of transfers of decision-making authority from the parent to some government agent. So sort of the classic example is a termination of parental rights hearing in an individual case. But you can also think of this in the context of a facial challenge to a law. This was what Troxel was about. This is about grandparent visitation rights. And the way the court thought about it was the sort of framework was a judge got to decide whatever the judge thought was in the child's best interest in terms of grandparent visitation, and that was the problem. That was the problem. The law sort of transferred decision-making authority from the parents to the judge in that case. And that's how I think about the school secret transition cases, right? Nobody thinks that it's inherently harmful or illegal to continue using your birth name and pronouns, right? And when an 11-year-old comes to a school staff member and says, I think I might be transgender, I want to change my identity, some adult needs to decide, are we going to allow this or not? And what these school policies do is basically transfer decision-making power from the parents to the school staff, and now they will make that decision for this individual child. And in my view, I think the rule there is that is always illegal. This is not a strict scrutiny. This type of case doesn't even sort of make sense with strict scrutiny. It's just you can never transfer decision-making authority from the parent to some bureaucrat unless you have procedural due process and abuse or neglect or unfitness. Then I think there's sort of a second category of cases where the state is broadly regulating something, banning some category of thing that indirectly affects a parental decision. And I think Pierce falls in this category. I think Prince, child labor laws fall in this category. And I think Scrutiny falls in this category. And here I think you have to just think about it a little differently. And here I think sort of history and tradition and strict scrutiny are helpful. Is there a long history and tradition of regulating medicine? Yes, of course there is. And is there a compelling interest in preventing minors from permanently being sterilized? Yes. Whereas in the Pierce context, education decisions historically were the province of parents. And one of the things the Pierce court noted is there was no evidence in the record that private schooling is inherently harmful. They didn't do strict scrutiny at the time, but it's sort of you can sort of reinterpret it in that way. So to my mind, at least, there are sort of these two buckets, and I just think they just fall in different categories here. Just to give one last example, in the Scrutiny context, I think it would be very different if instead of saying, these procedures are just inherently harmful, banned across the board, a state said, we think they're appropriate in some cases, but not others, but we're going to reassign decision-making power to, agency of the state to decide whether individual children get this treatment or not. Now that may sound crazy, but maybe coming soon to a California near you. So I think that would be a stronger parental rights claim than one where the state has determined just sort of universally this is harmful and we're going to regulate it.
I don't know that I have a lot to add there, but I think just on the decision-making component, I sort of think of this as spheres of decision-making authority. And to be clear, we're talking about very dangerous procedures on kids that we're seeing with the detransitioner lawsuits, like just the lifelong consequences that we're talking about for kids. And so it's no wonder that there are states that are looking into this and saying this is not safe medicine and we cannot have this being done to kids. But that's the sphere of influence of the state to decide and regulate medicine, and they have for a long time. It doesn't change the fact that parents have this inherent duty and right to make decisions about their kids' health care, like Melissa was saying, from the available health care It's almost like the parent steps into the role of the kid there and is making that decision for the child because the child's too young to make that decision for themselves. And so what would be available to that child is what the parent can choose from, and those are the decisions that are made available.
All right, I am interested in hearing now from each of you. Kate, I'll start with you. And I think the audience will be interested to hear this too, but what are the most important aspects, or what is the most important aspect of parental rights doctrine as it stands right now that you think could be or needs to be clarified?
I want to win secret social transition cases. I want those policies to be gone. You just see them hurting kids, and it's such an attack on every aspect of the parent's role. Religious upbringing, education, healthcare decision-making. It's like hitting every bucket of parental authority. And so I want those policies to be dead. In terms of clarity, I think we need some work on opt-outs. And I'm hoping you're going to get some of that from the Supreme Court in Mahmoud. But it's the area of parental rights that has such bad case precedent. Like Luke was talking about, there's sort of this gap in case law on parental rights. There's not a lot of case law on parental rights, I think in part because everybody until recently understood that parents make these decisions and it wasn't widely challenged. But now we see a government really stepping in a lot of these states and at the local level in these school districts and violating parental rights. And while school choice is a really critical and important movement, there are lots of kids that are still going to be in public schools. And so clarifying opt-out to give parents the ability to control their kids' education and direct it in the public schools, I think is critically important, and we need clarity from the courts on this issue.
Yeah, I think we really need the Supreme Court to weigh in on how to apply parental rights to new contexts. What is the test? Is it strict scrutiny? That's actually an open question in the lower courts. In Troxel, strict scrutiny got 1 vote. So it sort of confused lower courts as to, does strict scrutiny apply? It is a fundamental right, and we typically think of strict scrutiny applying to fundamental rights, and yet only 1 justice mentioned it. So what does that mean? Are we going to apply, is the court going to apply the history and tradition test that it's been applying in the Second and First Amendment context to figure out how far this goes? Or is it procedural due process? Mike Ferris has this interesting article that we should sort of re-envision parental rights in the procedural due process context. So there's just a lot of confusion, I think, in the lower courts, because the court hasn't weighed in on a parental rights case in so many years. And so to me, that's the big one, is just how do we apply this going forward? Is the court gonna limit Pierce to its facts, or is it gonna say, no, this is a broader right that applies more broadly, and if so, how?
Yeah, I agree, and I think it's crucial to clarify the confusion, because what happens in practice when there's confusion about the existence of a right, where it's anchored in the Constitution, what its scope is, what its strength is nobody says anything about it, right? So it becomes a self-fulfilling prophecy, because once you get a string of bad cases, as we did with the opt-outs in the 90s and so on, now litigators don't want to litigate on parental rights grounds. And so that's why you even see in Mahmoud, there was barely a mention of parental rights as an independent ground for the parents to win the case there, even though parental rights should be sufficient grounds for winning that case, even without religious freedom. Religious freedom is also sufficient grounds to win the case. But the fact that the briefing was almost entirely on religious freedom, with just a kind of footnote saying, yeah, parental rights is kind of part of this. That makes perfect sense strategically, given the bad prior case law in the federal circuits. But then it just becomes a self-fulfilling prophecy, because then the court never gets pushed to actually clarify this. So yeah, I would just kind of echo what was said, that it needs to be clarified in terms of the scope, that parental rights do not end at the schoolhouse door. They extend well beyond, in the public school context, to the right to opt out. And then secondly, the strength, that strict scrutiny ought to be the correct standard of review, because it is a fundamental right. And that also, I think, is correct on history and tradition grounds, that if you look at the strength of that right historically, what corresponds to that is what we currently call the strict scrutiny test.
On an optimistic note there, I just think on this topic, there's no way that the Supreme Court will be able to avoid it. The facts of these secret transition cases are just so egregious, and there's just a lot of motivation to bring them because they're so awful, and it just keeps happening over and over and over again. And so I don't think litigators are going to stop litigating these cases, even with some initial losses. I think they're going to keep being brought. It's already a mess in the lower courts. It's going to get worse. And so the court is just not going to be able to avoid this in the long term. It's eventually going to have to take one of these cases. And sometimes it takes a few pitches before the court sort of sees the importance of it. So only 2 of these cases have gotten to the cert petition stage. The first one got no votes. The second one got 3 votes. And there's a bunch more coming. So
The second one was Luke's, and it got a great dissent that I
yeah.
think is going to really telegraph what the court's thinking and get us to that 4th vote to get taken.
Yeah, and both those cases were on standing. It wasn't even on sort of the merits question. It was both cases lost on standing as parents who had sued preemptively. So the fact that we got 3 votes on a standing question, I think, is a strong sign that the justices are going to take one of these cases eventually. I don't know when it will be, but they just will have to.
Now, I have one more question before we open it up, I think, for Q&A, and we could probably spend a lot of time on this, but I think it's still worth touching with the time we have left. So these cases are inevitably going to make it back up to the United States Supreme Court. How do you see, and I guess, Luke, if you're willing to start us off, how do you see the justices analyzing these cases, and in particular, are there any justices that have shown an interest in parental rights claims?
Yeah, well, as Kate just mentioned, there were 3 votes to take our cert petition, so obviously yes. I think it's pretty likely the court will lean into this history and tradition test. That's sort of been the way it's going with a lot of constitutional rights, and so I wouldn't be surprised if it does that in this context as well. And I do think it makes sense in this context. I hope the court sort of carves out this procedural bucket, this sort of direct transfer of decision-making authority, like in Troxel, because I do think there is a separate category of cases where I just think the rule is and should be you just can't do it unless you have abuse and neglect and procedural due process. If what the do it is taking away the decision-making authority from the parent, giving it to somebody else. But we'll see.
What was the question?
When these cases get up to the United States Supreme Court, do you want to add anything about how you see any of the justices analyzing them, whether justices in particular have shown interest in these kinds of claims?
No, I would echo what Luke said. I think there is interest. We're seeing there's been 2 petitions recently. There was that were denied, but it's showing interest in the secret social transition issue. Taking Mahmoud, even though it wasn't billed as strictly a parental rights case, I think indicates some interest, as well as things like Scrutiny and Drummond. Taking those cases, even though Drummond didn't turn out the way we wanted, indicates an interest in this issue and things that are sort of adjacent to and impacting parental rights. And I'm hopeful that the court will step in and clarify things, because it has been a mess at the lower courts. As others have alluded to with the Troxel case, there's just been a real splitting in the lower courts about how do you analyze these kinds of rights? How do you protect them? What level of protection do they get? And that needs to be clarified, and is the kind of thing that calls for the Supreme Court to step in. You might see some back and forth about whether this sounds in substantive due process or privileges and immunities, which Melissa alluded to. I also don't think it matters that much. It's a fundamental right no matter where you sound it in the Constitution. But I think you could see some interesting back and forth on some of those issues.
Last sort of interesting tidbit I'd mention. So our cert petition, we filed, I think it was spring of a year ago, and then it got relisted a bunch of times throughout the fall, which suggests that the court was thinking about it. And then during the Scrutiny oral argument, Justice Barrett jumped in, and her question was like, parental rights is not at issue here, correct? Yes. And then they denied our petition afterwards. So I think they might have been holding it because she just wanted to confirm that it wasn't going to potentially impact our case. But all that goes to show it's on the justices' minds. I think we're going to see something in either Scrutiny or Mahmood, sort of dicta, footnote, separate writing about it, and they're definitely going to take one of these secret transition cases eventually.
I also thought it was interesting in the Mahmood oral arguments that both Justice Kagan and later Justice Thomas explicitly mentioned, well, wait, aren't there a lot of non-religious parents that also are objecting to these things? It doesn't seem like you have to be religious to object to 3-year-olds being exposed to these controversial ideas. So, I mean, I think that was telling, that they have this on their minds, including in the non-religious context, and that gives me some hope that at least in a footnote or something, there will be some distinct mention of parental rights in Mahmood.
All right, I think we have a few minutes now. I'm not sure exactly how we want to go about this, but we have time for questions. So I guess if anyone has one, I have a few more. But if anyone has one that you would like to ask our panelists, if you could just raise your hand, please. One.
I've been dying to ask lawyers this question. As a former teacher, FERPA, the Family Educational Rights and Privacy Act, to me seems absolutely unambiguous. That parents have the right to inspect educational records. What is common to every educational record is the child's name and gender, period, full stop. Can you explain to me, in childlike simplicity, please, how a secret transition and keeping 2 sets of school records can be anything other than a screaming FERPA violation?
It is a screaming FERPA violation, so you are correct. I think it's in FERPA. I know it's in Wisconsin state law, but I think it's in FERPA too. There's an exception for personal notes. So a teacher's personal notes about students in the classroom or something doesn't count as a record. So I think school districts were trying to say, these are personal notes, keep them out of student records. But obviously they're not personal notes. It's a form that's meant to put down how everybody in the school is going to refer to the child. So I think it's a very blatant FERPA violation. The problem with going that route is they don't have to write it down, right? So what some school districts have done is, put a big disclaimer at the top of these gender support plan forms that says, warning, this may be a record that will have to be disclosed to your parents if you don't want them to know, right? Sort of hint, hint. If you don't want your parents to find out, let's just not fill out the form, and then there's no record. So, schools can still do a secret transition without making records, because all it involves is how they address the student during the day, what bathroom they use, and the like. But I do think it's a clear violation, and I do think districts are recognizing that. So we just sort of one final anecdote. We sued the Madison School District, was one of them. We litigated for 4 years. The case ended up being mooted because all of the families left before we got to the end of the case. But after the case was gone, the district has removed the form from its website, removed the policy from its website. So they may still be doing secret transitions, but they recognize the liability of the FERPA violation. They're trying to hide it at least.
And fascinating, some of the districts are trying to use FERPA as an excuse for what they're doing, to say that somehow FERPA means that the child's records are private even from their parents, which is just on its face ridiculous. And you did see in the Marabelli, one of the early decisions, the court said that's ridiculous, that it's actually the opposite. FERPA, they're telling everybody but the parent, when FERPA is designed to protect just the kid and the parent know, and everyone else doesn't. So you do see it kind of going both ways, the way that's being used and incorrectly.
I'm just wondering if there's any criminal cases involving these cases that are more aggravated mutilation. For instance, cases in the nature of aggravated battery or aggravated kidnapping.
I'm not aware of any that are criminal in nature. And we looked a little bit into some of the criminal statutes and didn't really see, I mean, obviously as a civil attorney, there's not a way that we can pursue that, but I don't know if you've seen any.
Yeah, I haven't seen any either. Same answer. Yeah, it's an interesting thought.
Can I ask, why isn't social transition considered a medical intervention?
I mean, I think it is, and there are articles in medical journals that say it is, and it should be treated as one. It's clearly the first step in a process of more explicit medical interventions that are pharmacological and then surgical. But even the social element, I mean, it's meant as a mental health intervention. Now, there's no evidence that it actually helps, but it is meant as a mental health intervention, which would make it a medical intervention.
Yeah, I think it is, but that's been a major focus of the litigation is putting it in that box, in part because sort of the counter argument or counter intuition is, what's the big deal? This is just a nickname. They can change it next week. You know, why does this matter? And so obviously, I think it is hugely important, hugely impactful in a child's life to have all the adults around them all day treating them as if they are the opposite sex. It adds to the confusion. It can potentially sort of cement in this belief that they are born in the wrong body. But we've really had to make that case to the court, in part with experts, in part with citing studies and the like, to put it in that box. It's always been bizarre to me that schools believe they can't give a Tylenol to a child without getting parental consent, but they can change their gender. It's bizarre.
I signed off for sunscreen at my kids' school. Agree. It is, and they were seeing experts now come out and be able to establish that in court, that this is a medical intervention. I'm not sure it entirely matters, because it certainly puts a child on the path to further medical interventions and surgeries and things. And so the parent's right to make decisions about things related to healthcare should go beyond like a specific procedure or specific surgery. Everything that's going to impact that child's mental health and physical health should be part of the parent's role as a decision maker. But yes, that's been something that you're seeing pop up in the cases and being discussed by the experts, is where does this fit into parents' healthcare decision makings and the healthcare of that kid.
All right. I think we have time for one, maybe two more, depending on the time. I think we have two.
We won't all answer, and then we can get more in.
We touched on FERPA, and then we've talked about the medical care. A lot of medical practitioners outside of the schools use HIPAA as an excuse to separate parents from their children and not let the parents know, without their children's approval, what's going on with the child. How does that stand with parental rights?
I'm laughing because Jordan's sitting in the back and he's trying to convince me to file cases on this issue. But we are seeing and hearing from a lot of parents that HIPAA is being used to keep them from medical records, and that a lot of state hospitals, medical facilities, even in the military, parents aren't able to get access to their kids' medical records after a certain age. And this has real life consequences. We're hearing from parents who have kids that need regular blood draws to track certain things, or their medication is tied to certain testing, and then they can't get access to those records. So that is a growing issue of concern, absolutely.
Luke, you mentioned how scrutiny in the lower courts and some of the sister cases consistently lost. The federal district court, the plaintiffs won, challenging the state laws. What I think is a tremendous silver lining is you had all of these district court judges who might not agree with parental rights in the way that we've heard tonight say with full confidence that parents have a constitutionally secured right to determine medical care on behalf of their children, that it should have strict scrutiny applied to it, and the state's law fails. So I think that's incredible. I'd love to hear you respond to that. But then also, what do you think then would happen in states that have preemptively removed the right of parents to make those decisions for things like mental health care, or STD treatment, or substance abuse treatment, something like that?
Yeah, it's a good question. I got to think about it for a second.
I'm glad he asked you.
Yeah, I mean, certainly as litigators, we'll use those cases, right? If courts are saying there are parental rights, they exist. I think the application is wrong, but I think it's certainly helpful to have courts saying this is a real thing that's out there, and here's the standard that gets applied. Again, I think it's different for all the reasons we've already talked about, which is when the state is sort of regulating a medicine that is deemed unsafe for everyone, that is consistent with what the state has done historically. That's not stepping into the shoes of the parents directly. Certainly, it's an indirect effect on what parents can do and can't. Yeah, I guess that's all I would say about it. Your last question, I don't know. Do you guys have thoughts on that?
I mean, I'll just say one thing that I think. I mean, I think it's a big problem that maybe it's something for further litigation down the road once we clear away the secret transition things and the opt-outs. But the presence of mature minor laws allowing kids as young as 13 and 14, maybe even younger in some states, to make medical decisions, at least on certain things, independent of their parents. I think it's a huge parental rights violation, and it's very bad for children. And in my understanding, most or all of these laws were passed at a time when we did not have, when we didn't know what we know now about brain development, right? So people thought, oh, 13, 14, they're mature enough, right? Now we know the brain actually isn't fully developed until 25, and at 13 and 14, they have a long way to go in terms of, full adult mature decision making. So I think even the kind of evidentiary basis for those laws is now, completely undermined with new research. But beyond that, I think it's a parental rights violation. So that might be something to think about for future litigation.
It's a really challenging question because where does the Constitution draw the line at what age, right? We take sort of 18 as the age at which you become independent from your parents and they no longer have decision-making authority, but what if the state pushes that down to 17? What if it pushes it down to 16? What if it pushes it down to 15? Does the Constitution dictate those lines? Those are really hard questions. And that's where we as litigators sort of look for the best facts, the early litigation, but we need some clarity from the court on how to apply this right to new contexts. And if it got to that question, what age, I don't know what they would do.
All right, well, if everyone could thank our panelists here today, I think we're going to get ready for the next panel.
Thank you, Corey, and thank you, panelists. We're going to take a very brief break of about 5 to 10 minutes. We will reset the stage, and we will have our second panel at precisely 6:15. See you then. Okay, welcome back. Normally when I start panel discussions like this, I usually start with introducing my panelists. In this case, I feel like I should say, Avengers Assemble. Just given the nature of who's on this stage. I'm even guessing that all of these folks may be familiar to you. Tiffany Justice, at my extreme right, is a visiting fellow in parental rights at the Heritage Foundation, and she was a co-founder of Moms for Liberty. Will Estrada, second to my right, is senior counsel at the Homeschool Legal Defense Association, or HSLDA. And to my immediate right is Nicole Niley, the president and founder of Defending Education. Well, our previous panel set a very, very high bar for us, so we're going to have to do our best. But knowing you as I do, I assume we will be bringing the fireworks here. Let's start with a slightly personal note, can we? When you think about this idea that the child is not the mere creature of the state, granted, we're all parent advocates in one form or another, but what does that mean to you as a parent, not as an advocate? Nikki, why don't you start us off?
So a couple years ago, we moved to Austin for like a brief fugue, and when I got there, I was trying to move all of our stuff over, your house stuff, and I remember reaching out to the city of Austin. I was like, I can't figure out how to register my dog, and they were like, what are you talking about? You don't have to do that here, and I was like, and I know there's going to be some hit piece saying Nikki thinks children are pets, but it's at the end of the day, it's that I think the point I'm trying to make is that I think we have become as parents so accustomed to asking for permission for everything. That is now the default setting. I mean, I think my kids were only in public schools for a year. And when we had to register them, you had to check that you read and agreed to all of these 45 provisions. You can use my kid's picture, you can do this, you can da-da-da-da-da. I'm married to a constitutional lawyer, and I was looking at this, I was like, I don't want to, I disagree with this provision and that one, but you can't line item edit the things that you don't want a public school system to do to your child anymore. And this was right after COVID, when you were not allowed to enter the school building. It was all right, and so I wasn't allowed to see my kids in person. I wasn't allowed to see the schoolroom, and it was I felt like it was Oliver Twist, please, sir, some more. Please, can I have a little window into my child's education? And we would get this email at the end of every week, okay, this week we talked about the 60s, and what part of the 60s? Were you talking about the Beatles or the Weather Underground? Help me help you. I want to be a partner in my child's education. If you're doing a lesson about World War II, then I'll make schnitzel, we'll watch The Great Escape. I want to help bring these lessons to life. But we are now being kept at such arm's length, and we are perceived as the enemy. And that is what I see happening in far too many school districts across the country.
I have to say, as a former teacher, that phrase that we're ruminating about today, the child is not the mere creature of the state, it wasn't until after I left the classroom that I heard it for the first time. You would think that would be an important part of any teacher's education and acculturation, but that was not the case, at least in mine. Will, can I have your reflections on that question?
I love that line in the Harry Potter series when Dumbledore says to Harry Potter, "Love, Harry, it's the greatest magic of them all." And when I think of parental rights, my wife Rachel and I have been married for, actually this year will be 19 years, and we have 2 kids, Dominic, who's 13, and Merrick, who's 8. And the first time you see them, when they're born, that love that you have that just fills your heart. And the interesting thing is I have great love for my kids as a dad, but I know that even a mom's love is even higher than I think even a dad's love of going through the birth and carrying children. And then you take that into raising them, watching them take their first steps, educating them, whether you're public schooling, putting them on the bus for the first time, or we're homeschooling them, teaching them to read, or private schooling. It's that love that you have as a parent for your children, and that is what is so critical. And I think that's what motivates, I know everyone here on this podium, but I think everyone here in this room and those who are fighting those battles, love for their children.
Yeah, I mean, I would die for my children in defense of them. I mean, Mrs. Palo taught my children kindergarten, but is she willing to lay down her life for my child? I mean, I think there are some that argue and say, yes, teachers do in fact defend children in schools when we have adverse situations happening. But in general, this idea that we have government schools, and we do have government schools, so I think calling them public schools at this point is a mistake. These are government actors, teachers are government employees, and the idea that when you have your baby, baby, no one questions who's going to name the baby. It's not like up for debate. You don't call the mayor and say, "Would you like to weigh in on what I name my baby?" Is there? And it's my understanding that in certain countries there are certain names that you can't even use, but in America you can name your baby what you want. And if you worked in the education system, you've seen a lot of names. And so the idea that there's no question about that, but then somehow, your child's 12 and they're confused about their gender, and the school can rename your child without your permission. It's just crazy. And I was watching the last panel and really thinking to myself, what if we didn't have the Supreme Court? What if Mahmoud was in question? What if the Supreme Court, and we have a justice who doesn't know what a woman is, so this isn't that far away, what if the Supreme Court said, well, you know what, we actually think that there are a lot of crummy parents, and we think that the state does have a compelling interest and should be, overriding parents' decisions. What would we do? Would it change your fundamental rights as a parent? I mean, and it wouldn't. And I think it's important for us to really, as parents, to really stand up and say, these are our children. The government doesn't get to make decisions for them. And I think, COVID would have had a very different outcome if parents had together stood up and just said, no, these aren't your kids.
I'm fixated on this idea that we don't call the mayor to name our child. I'm from New York, so that is definitely not something that would have ever entered my mind. Nikki, and I'm going to ask Tiffany this question as well. Looking back at the last couple of years, especially during the pandemic COVID era, there is obviously a resurgence of interest in parent advocacy. I mean, Tiffany, you founded Moms for Liberty. Does that momentum reflect sort of a Pierce-style principle at work, or something else entirely? Or to say it more bluntly, are we having this conversation if there was no COVID pandemic?
I don't think we would be having this conversation if there wasn't COVID. And so it's weird to say this is the silver lining, but I think probably yes. I mean, you said in your opening remarks, parents finally had a window into what their kids were learning and were not learning. And I think people were kind of universally disgusted. I mean, one of the things that sort of kickstarted me wanting to start Parents Defending Education at the time was I am from Chicago, all my friends are Democrats, and I started to get text messages from my friends at home, and they're like, I really want my elementary school to reopen. How do I talk them into that? And I remember thinking oh, bless your heart, you think they care. But I was really struck by just the fact that people didn't have a fundamental understanding of how the education system works, that parents really thought that they were stakeholders and that they were partners in this endeavor. They are not. I mean, you're not even considered a consumer. You're just supposed to sit there and take it, right? You're gonna have to pay into the system no matter what. And I think people were really wait, what? You don't, I don't have any insight, any input. And, I mean, let's think back to, schools were closed in 2020. At the beginning, everybody was, pretty panicked. But then, fast forward a year later, and we had Terry McAuliffe saying that, parents don't have a right to be involved in these decisions. And people who weren't, red-pilled with schools closure, I think at that point, they were I beg your pardon, what? And so I think it was sort of this snowballing of everything. Where parents didn't realize how far out of the picture they had been pushed until it was too late.
Tiffany, you have some insight of this as well as having, in your previous iteration, formed Moms for Liberty, but no COVID, no Moms for Liberty?
I mean, COVID was a blessing. I say that. I made, with Moms for Liberty, we make COVID lemonade every day. Because without it, I honestly think we were losing our country. I think people should be very cautious to say that we aren't still losing our country, because there's still the capture of major, institutions. I think education, the judiciary. I think, we need to be fighting hard for the future of America. But I think no COVID, no Trump second term. No COVID, no real window into what was happening in the schools. And we are in the middle of a cultural revolution. The schools are a major battleground, as Nikki and Defending Education have shown through FOIAs, all of the documents. People in America who didn't think this was really happening have hard evidence now to see the indoctrination happening in schools. I love teachers, but we do have activist teachers. I was reminded by my good friend Ginny Gentles to talk about the colleges of education and the indoctrination that is happening, and these teachers that are coming in and truly want to change America. They're not having their own kids, they want our kids. They're using our children to change the fabric of our country. So no, without COVID, we aren't having this conversation. And I really think American parents were very busy living their lives, sending their kids to school. And when you recognize that something's broken in your kid's life, you have to fix it. And it takes a lot to change your kid's school. It's a big change. And so people, they want to like their kids' school. They want to feel like their kids are doing well in school. And, public schools are fairly convenient for parents. And so it really was just this moment of, okay, wait, I've been on autopilot, and now I really have to assess whether or not my child is thriving.
Yeah, I'm not going to call it a silver lining exactly, but for the last 15 years since leaving the classroom, I've been a curriculum guy, trying to get practitioners and policymakers to focus on curriculum as opposed to, it's just that stuff that happens in the black box. So yes, the lid was ripped off that black box, and for good or for ill. I wanted to have Will Estrada on the stage to talk about homeschooling, which I think is a underdeveloped part of this conversation. So Will, and granted, 50 states, 50 different sets of regulations, but could you, to the degree that it's possible in a couple of minutes, just describe the ways in which current state regulations support or interfere with the ability of homeschooling parents to educate their children at home, and how does Pierce factor into the current state of play in homeschooling?
Yeah, it's a great question. And the first way to look at it is, imagine if we had lost in Pierce. Now, I'm not going to give a land declaration here, but I love giving Supreme Court declarations. And today, June 4th, 102 years ago, was the precursor to Pierce versus Society of Sisters. That was the case Meyer versus Nebraska. That was, of course, Robert Meyer teaching one-room schoolhouse, German, prosecuted, lost before the Nebraska Supreme Court, but then that conviction was overturned by the U.S. Supreme Court, and it was the first case that first said parents have this right, substantive due process, 14th Amendment, to make decisions, including to choose a school to teach their kids German. But it was a 7-2 decision, and imagine if that case had turned differently. Then 2 years later, Pierce was a unanimous decision. And so when you first think of homeschooling and Pierce versus Society of Sisters, imagine where we would have been if we had lost in Meyer and if we had lost in Pierce. I don't think we would be having this discussion. I don't think homeschooling would have ever been legalized when the modern homeschool movement began in the 70s and 80s, because that Meyer, Pierce, and then Wisconsin versus Yoder were those cases that established that. So specifically to your question, there's 50 states, 50 different rules. You've got 12 states where there are no requirements that you check in with the government. There are 4 states that have high regulation, including Massachusetts, where you actually have to wait to homeschool until you get approval from the school district. But in general, all 50 states, from the states with minimal government regulation, minimal government red tape, to states, the 4 ones that have, I would characterize as high regulation, and those are, of course, Massachusetts, as I said, New York, Pennsylvania, and then Rhode Island. All of those still respect the fundamental decision of Pierce that the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to prepare the child for additional obligations, the quote from Pierce versus Society of Sisters. What we are seeing, however, is a fairly recent trend to try and reverse that. And it's being led by academics like Elizabeth Bartholet, who famously wrote in the Harvard Law Review back in 2020 that homeschooling should be presumptively banned. Last week, when we had the event at Cato, we had James Dwyer from William and Mary. James Dwyer is a professor who actually said there at the Cato Institute, when we were marking the centennial of Pierce versus Society of Sisters, that you shouldn't be allowed to leave the hospital with your newborn child until you do a background check with the government.
I was there. He said it. It was fascinating.
You could back me up on that, and Tiffany rightly took him to task on that. So we are seeing now an attempt, so far it's been beaten back, but an attempt by certain state legislators to reverse the gains for homeschooling, and I would argue to reverse 100 years of precedent from Pierce versus Society of Sisters.
I would just add to that I think there were a lot of parents who before COVID were like, oh, I don't know, to Nikki's point of that we kind of thought that we don't teach our children, someone else teaches our kids, and we just kind of got used to that. Said, okay, wait a second, maybe I could homeschool. Yeah. Because I'm watching my kid at the kitchen table, and the teacher's wearing a mask or something in her house, and I'm watching as it doesn't. My kid's not doing very well. Obviously, what's been happening in the school hasn't been so great, and now the quality of the education that I'm watching them receive isn't great. And so parents got a little confidence and said, well, maybe I'll try homeschooling. Maybe it's not something that I can't do. Right? That was important.
Yeah, I don't know what the current figures are, but I recall coming out of COVID that the rates rates of homeschooling had literally tripled.
Yeah, U.S. Department of Education now says it's between 5 and 7% of the school-age population. Remember that about 10% of the school-age population are in private schools. So we are, for the first time in modern history, looking at almost 20% of the school-age population are no longer being educated in government schools.
Yeah. I wanted to follow up on my question. In the previous panel, we heard about a bewildering number of lower court cases, mostly around social transitioning. Are there similar cases, Will, that we should be paying attention to that are wending their way up through the courts that affect homeschooling?
You know, the interesting thing is we have not had a major homeschool case in courts since 2008, and that was a really weird case. It's called In Re Jonathan L. The California Appellate Court said homeschooling is not something that anyone does, and it's illegal. And there was such an outcry. Remember, Arnold Schwarzenegger, the governor, was the governor back then in California. He even came out and said, no, this is ridiculous. The Appellate Court in California did kind of the unprecedented step of vacating their own decision and saying we're going to rehear it. My boss, the president of HSLDA, Jim Mason, he was our director of litigation. He actually was part of the team that argued that. I believe Alliance Defending Freedom did an amicus brief. Many other allies did as well. And a few months after they got that decision, they said we were mistaken. Homeschooling is a long history in California, and it's legal. And that was actually the last time that there has been a court case in the United States dealing with specifically, is homeschooling something that's constitutional or legal?
We want you on that wall. We need you on that wall.
Very good. I was going to ask Tiffany this question, but really anybody could answer it. And I'll steelman this a little bit, right? So some critics have argued that school choice weakens our civic fabric when we allow parents to opt out. How do you view that question or how do you respond to the claim that a common school system is necessary for a healthy democracy? I'll start with
Would you like me
Tiffany.
to start?
Yeah, but anybody else can answer as well.
Yeah, I mean, I think that school choice enhances parental empowerment, which I think is good for the country. And I think that, I kind of go back to the Mahmoud oral arguments and thinking about what's being taught in the schools. You have Jason Bedrick, a colleague of mine, has talked a lot about the fact there's no such thing as a values-neutral education. You've talked about this as well, Robert. And so when they were discussing Mahmoud and the idea that parents weren't allowed to opt out of this curriculum, Justice Barrett brought up, there's a difference between exposure and coercion. And it became very obvious that the Montgomery County School District felt like it was in the best interest of society as a whole, of Montgomery County, for these children to have to go through this Pride storybook collection. That the parents not wanting to do it was even more of a reason why it needed to be done. And so I guess the question really is, like, the civic fabric that you're talking about, what is that, right? And I think traditionally it's existed outside of the school system through different institutions, through church, and certainly through family. So I don't think that the public education system has to exist in the way that it does, or all the children have to go to the school in order for us to have a strong civic fabric. In fact, I think it was the National Center for Education Statistics that said that kids who were outside of the school system, whether in a charter or in a private school, had a better understanding and more involvement and more civic engagement. So, I think that maybe the teachers union wrote that question.
Either one of you want to have a bash at that, about whether we need common schools for civic?
This was actually what led to Meyer versus Nebraska and Pierce versus Society of Sisters, that we don't want the Eastern Europeans, we don't want the Roman Catholics, we don't want Jewish families coming in, and so we're going to use the public schools, which were back then mainly Protestant, to indoctrinate kids against what their parents want to teach them. And the court rejected that. This is pluralism. We live in a very pluralistic, diverse, large country. Interestingly enough, countries like Germany, where homeschooling is banned, the reason for those bans is that they don't want a kind of diversity. They want everyone to have a homogeneous education to build the civic civic fabric. And I always say, who has kind of a stronger civic fabric? Is it Germany or is it the United States? I would argue our country does. And just, I love the writings of Yuval Levin and A Time to Build. And of course, he's here at AEI. And his book, he talks about the importance of civil society, houses of worship, even just clubs and organizations. That's what builds a country, not a common education system. Kids are diverse, kids are different. They learn differently. And that's what our education system should look like.
Is there a limiting principle, though? Can you envision a piece of the curriculum, a lesson, a class, that you are willing to say, no, kids should not be able to opt out of that?
Like reading,
Okay.
which isn't happening in our schools right now. I mean, a third of kids reading on grade level in America's public schools. We could start there, put a focus on reading.
And legally, a limiting principle would be anything. Think of a First Amendment context, for example. Anything that's inciting violence. You can't have a militia training camp and teach your 5-year-olds how to carry Kalashnikovs and build bombs, sort of thing. That's not education. That's disruptive. That's criminal. That's inciting violence. So there are certain limiting principles. Again, some of it even goes to the issue of parental rights. It's not an absolute right. It's a fundamental right. You cannot act in a way that actually harms a child. And I love our former panelist, Melissa Moskela, her book, To Whom Do Children Belong? She writes about how if a parent is acting in a way against nature that's destroying that love of a child and love of a parent for a child, then the state should step in. And the same sort of thing happens with education.
I mean, I think, when we send our kids to school, we expect reading, writing, and arithmetic. But we have also watched those disciplines get perverted as well, right? I mean, there's equitable math now, right? There's equitable grading where nobody gets a 0 anymore. And so even kind of the basic things that we expect, I mean, our kids are in a school for 7 or 8 hours a day. And I expect them to be spending that time learning and not spending, 6 of it wasted on talking about big feelings and navel gazing. I expect them to actually be working on subject matter stuff. And frankly, in a lot of cases, they're not. I think a couple of years ago, the Michigan Democratic Party had a Facebook post that was up very briefly, and they had to take it down. It said, the purpose of the public school system is to teach children what society needs them to know. And I think, they got dragged for it. They took it down immediately. But I think, they're implying that what families want their kids to know is not, that does not comport with what society needs them to know. I mean, I pulled my kids out of school because one of the things that they had this really explicit sex ed curriculum. My son came home and he knew all about pansexualism. I'm in my 40s and I don't know what that is. I don't know if he needs to know that, but that was what the school determined, and I felt that didn't comport with our values. And so when other people are making those decisions of what your kid must know, I start to get very queasy about that.
Again, a question for anybody. Can you comment on the current state of play with curriculum transparency? I mean, I think this was one of the other things, your phrase, a silver lining that came out of COVID, was suddenly not only were parents interested in what their kids were learning, but they demanded some visibility into it. I haven't heard as much about it in the last year or two that I did coming right out of COVID, but what's the current state of play with curriculum transparency? In other words, how do we know? We saw it on our kitchen table during COVID. Are we still seeing it?
Not really, and it's really hard, honestly. I mean, we file a lot of public records requests, sometimes on behalf of parents who are too scared to ask for this stuff themselves. And one thing, a roadblock that we have started to come up against, or the families in general have, is that copyright. So and it's not necessarily from a book company. It's from a lot of the independent consultants that are selling their services to schools. And so that is something I think that's interesting. Southeastern Legal has a case right now that's in, I think, the state of Kentucky. Goldwater has great model legislation about this. I know you have done work because even when we say we want curriculum transparency, it's not that everybody is using the same books, the same lesson plans, where it is very much a patchwork. And so, while my heart goes out to teachers that are trying to cobble stuff together, I think on some level, transparency actually might help some of these teachers to see what their peers are doing and using. So, but I think the state of curriculum transparency is not good, TLDR.
And I would also say that one of the biggest issues is the teacher's manual. The teacher's manuals are sometimes very prescriptive. So a book that you would think we wouldn't really have an issue with, the teacher is directed to engage with the students on a thought adventure about that book in a way that perhaps you wouldn't normally think about. And Ruby Bridges Goes to School is one of those books that you would on its face say Ruby Bridges is a hero. But apparently there are a couple different ways to teach Ruby Bridges, and when the kids in Tennessee went through a 9-week civil rights module at the age of 6 and 7, it ended with a little boy coming home and saying to his Thai mom, Mommy, I don't want anyone to know that Daddy is white. I don't want him to pick me up at school. And so, a tree by its fruit, and the idea that we're teaching kids in a classroom in a public school that somehow, the color of their one parent's skin is bad is just horrible. I'll tell you, the other issue is supplemental curriculum. So you have standards that are adopted by a state. You have curriculum. Those standards, think of that as like a roadmap. You have curriculum that then is adopted at the school board level. Then, parents can be a part of that process. That was one thing as a school board member when I served. There was a committee that was, put together. And when curriculum's being adopted, we'd really encourage community members and parents to come and be a part of that review process. You saw in Florida that parents were a part of that review process and said, wow, there's this woke information in this or that, and the state went back to the curriculum manufacturer and said, you're going to have to take this out or we're not going to buy your curriculum from you. And they did take it out. They were successful. But supplemental curriculum is a huge issue. It's like shoveling with a rake if you're not getting the supplemental curriculum out. And I just will tell you, my own daughter in 9th grade was reading Catcher in the Rye, and then in class watched something called Thug Notes. If you don't know what that is, Google it, go watch it, you'll be shocked. And it was just shown in the classroom. And the principal had no idea that it was even happening. She told me about it, I watched it, I let the principal know. I'm on school board at this point, and said, hey, do you know this is being used? And he had no idea. And so supplemental curriculum is a huge issue, teachers having the discretion to really bring anything in the classroom. And as a parent, you have the fundamental right to know what's being taught to your child, to direct your child's education. And if you are constantly reacting to something, then you have no ability to direct it.
I'm going to see your supplemental curriculum and raise it. I never tire of pointing out that curriculum adoption is a bit of a misnomer. In other words, this has always been my fear about curriculum transparency laws, is that it can create a false sense of security. In other words, once I know what the curriculum that has been purchased is, now I know what my child is learning. It ain't so. This sounds like a made-up figure. I promise you it's accurate. According to a RAND study, 98% of teachers in this country use materials that they either create or curate, find on, Share My Lesson, Teachers Pay Teachers, etc. So if you think you know what's happening in your child's classroom because you know what the curriculum is, even the supplementary curriculum, the extra things that they do, we literally have a system where teachers are calling audibles. And let me be clear, it's not for bad reasons. It can be for differentiating instruction, for engaging kids. But it is very, very hard to know with confidence. The transparency days that we had during COVID, where it was literally coming into your kitchen table, maybe we're going to miss that.
And you know how you solve that is by volunteering in the classroom. I just
Volunteering.
with volunteering and being in the school and being in the classroom, I would just say that a lot of where we've gone in public education wouldn't have gone so far. The violations of parents wouldn't have happened if more parents were actually in the classroom watching what was happening, and how the teacher was teaching. But to Nikki's point, parents have been pushed out, and then certainly during COVID. You weren't allowed in the schools at all. And there are some schools, I don't even know if New York City Public Schools lets parents in at all. Still.
Yeah.
No, we had a FOIA last year where we were looking at, in Arlington Public Schools in Virginia, there was a teacher who was very active on the Palestinian issue. And through all these emails we got from the school, it was the principal saying, can you explain how all of these lesson plans about Israel, about, genocide, et cetera, how does this relate back to the ESL standards for the state of Virginia? She had gone so completely off script, and he didn't know, and then when he found out, he couldn't actually rein her back in. And so, what do you do as an administrator at that point when somebody has totally lost the plot?
Yeah. I was going to ask you if you've encountered moments when you felt your input was unwelcome, but that's almost too much of a softball because that's what you do for a living, right? Is make yourself a pest. So I want to ask the opposite. Have there been instances when you've been welcomed in your role as parent advocates? I was afraid that was the answer.
It's been funny because over the past couple years, I feel like we have grown up with a lot of these parents. I think back to 2021 when we were getting off the ground, when Moms for Liberty was getting off the ground. And these are people who were not sophisticated political operatives. These are people who had a window into their children's education, were horrified, and then were called members of hate groups and, likened to being local QAnon people. And people were scared, right? And so as we have worked with people, we have watched them grow up. We have watched them get more sophisticated. Some of them have run for school board or office, have won. That has been really great. And watching people kind of gain that confidence. Through our tip line, almost 100% of the tips that we have received, people check that they want to be anonymous. But watching people find their voice, being, getting expertise in different subject matters has been really awesome because, I mean, I think of it almost as like rebuilding the fabric of society. I mean, when it came to COVID, I think, America's civic engagement muscles had more or less atrophied. People didn't know how to push back effectively at the local level, at the state level, at the federal level. They didn't talk to their neighbors. And then we saw people kind of start to come out of the woodwork and band together, create these parent groups. And it is, I mean, in the absence of, right, there's like we have problems with faith. I know AEI runs programming on that all the time, right? That like there are not a lot of these civic organizations that used to exist. And so for people to come together and unify around schools has been something that's really awesome. I mean, even look at the Coalition for Mahmoud. I mean, Montgomery County did something that, like, frankly, we have not been able to do for the past 2,000 years, which is to unite Jews, Christians, and Muslims all on the same side of an issue. My God, that's amazing. And so, to watch something like that happen where, so I don't know. I think that we've gotten good feedback from parents.
I
so
think,
that has been
yeah, and I think, I served on school board for 4 years. So did Tina, the co-founder of Moms for Liberty. And then our drive was really to get more parents involved in running for school board and to repair the relationship between parents and school board members because the unions were just so loud and so powerful. I would sit on the dais and you'd have red shirts, a sea of red shirts, and a vote would come up, and I would know how the fellow board members would vote on an issue, and then you'd have the union come, and they would flip their vote on a dime, and it was really wild to watch. And we were just like, man, we need the parents. The parents need to be here, and we need to have their voices heard. And so I would say that as parents have exercised their muscles and understood, one of the things at Moms for Liberty that was very important to us is we wanted parents to be effective advocates. They were getting up at school board meetings during COVID and they were getting upset. They were being ignored and then they were getting upset. You'd see them yelling, "Why aren't you listening to me?" Scott Smith's daughter gets raped in a bathroom, right? And he's upset and he gets dragged out of a school board meeting. And then you have the National School Board Association who is taking up for the teachers union, and the teachers union boss is learning losses. Randy, I hope you're watching, kept schools closed and hurt a generation of children. But they collaborated to have parents called domestic terrorists and to get the National School Board Association to write a letter to the Department of Justice where the FBI, the premier law enforcement agency in the United States, was weaponized against the American people. And so, they wanted an adversarial relationship, and I'll just really give the moms and dads, and certainly Moms for Liberty, but other parent groups that rose up across the country, a lot of credit for saying, okay, wait a second. We are going to figure out how to engage in a meaningful way. We are going to ask for conversations. We're going to sit down and build relationships with these school board members. And they have made incredible progress. And so there are many stories now. And I think there are many educators who for so long were stuck in a captured institution that the left owned, and they didn't see a way forward for them to be open about their positions or their feelings or to throw the flag and say, this has gone too far. And now with the support of parents, they feel they can do that.
Okay, but, and I'm not trying to just play devil's advocate here, but there's, 3.7 million teachers in this country. Surely half of them at least are parents themselves. Even if it's, sotto voce, as it were, you've got to be hearing from some teachers, even privately, right, saying, these folks have a point.
Yeah, but during COVID, I remember one of the teachers in my district got up and she was very upset about what was happening in the schools. She was I think she was a speech pathologist or something, and she knew that the kids were really struggling with the masking. And she spoke out and said that she was supportive of changing the masking. And on her way back down to her seat, one of the other union members, no joke, went like this to her. And so the pressure within the school districts on the teachers unions, and not all the teachers that are involved in teachers unions. I think some teachers are union members and they believe they have good reasons for it. I would say to them, save your money. The parents are here. We're going to help you get out. You can have a better paycheck. But yeah, I mean, there's just tremendous pressure on the teachers from the teachers unions.
You know, Robert, your question made me think. I am actually a perpetual optimist. 100 years ago, think of where we were with Pierce and Meyer. The future of private schools, you know, Society of Sisters of Jesus and Mary, was at stake. I mean, private education was going to be destroyed, and the private schools won. As recently as 1996, homeschool parents in Michigan were facing jail time for homeschooling. Today, homeschoolers don't get thrown in jail anymore in the United States, and homeschooling is mainstream. Really, the battle over parental rights now is mainly in the public schools. So we won in private schools, we won in homeschools. And when you think of homeschooling, it's how many things can we think of in the United States of where we have more freedom now than we did 100 years ago? There are some, but homeschooling, private schooling, we have massive amounts of freedom in those. It's a success story. When I was in Illinois this spring testifying against a terrible bill, it went down to defeat, HB 2827, 8,000 homeschoolers came out, so many that the fire marshal shut down the Capitol in Springfield. And it really is exciting to see, you know, the homeschool parents, the public school parents that Tiffany and Nikki work with all the time, and so many others, they're banding together. There are still fights ahead, but some of these victories, Pierce being one of them, show that we can win these fights as well.
Somebody commented on trust, and this is an issue that I've thought about quite a lot. It's almost a bromide where folks in the public school world say, "Well, parents don't trust us anymore. Look at these folks who are roiling the waters." But I like to point out that when you ask teachers, and I think EdChoice has polls on this, when you ask teachers, "Who do you trust?" The top is my colleagues, my administration, my union. At the very bottom is parents. Almost universally, every time they've asked that question, I think parents end up near the bottom with the least amount of trust. Surely this conversation, I'm not going to say it doesn't help trust. These are important issues, and parents come first. Do you see common ground here? Is there an opportunity? Because I agree with you, Tiffany. The public schools are not going to go away. I think we're definitely all choice people on this panel, but the public school system will always be with us in some form or another. Is there room in this discussion? I'm seeing Will's optimism, and I want to reward that, as it were. Can this marriage be saved?
Yes, when we destroy the teachers' unions. The teachers' unions are the foot soldiers of the progressive far left. They do not care if kids are learning how to read in school. If they did, they would talk about reading at their summer conferences, but they don't. They talk about all social, cultural issues. And so we don't, I think our country is in danger until we find ways to limit the influence and the scope of the teachers' unions. And I'm very dedicated to making sure that happens.
Will, Nikki?
No, to that point, you look at what the NEA, the resolutions they introduce at every conference, the AFT during their summer events. A couple years ago, they voted down to recenter schools on quality and education, right? But they do vote on restorative justice. They vote on abortion. They vote on Palestine. They vote on Ukraine. They vote on basically everything except for what they should be focused on. And also, some of those policies, like the restorative justice stuff, that directly ends up hurting and impacting their members, right? No teacher wants to go to school and be punched in the face by a student, right? Going to the principal's office and singing Kumbaya doesn't make it better. And so, things like that where the unions are not actually advocating for their interests. And, I think all these other mandates and all these other things that unions are pushing for, be it the SEL lessons or, the restorative justice stuff. A teacher goes to school and they're paid $50,000 a year to be a math teacher. They're not there to be an emotional support animal, a gender support counselor, a punching bag. And that is what we are putting on these teachers right now. And so I do think there is a real opportunity to make common cause with teachers. And I wish there was a teachers defending education org out there to help to bring them together. And this is well outside my area of expertise. Title VII is a mess. Sorry, that's going to be a you guys problem. But I do think that there is a there, and that is kind of to me the missing piece of this puzzle.
Yeah. I asked earlier,
Robert, just one interesting thing about that is. These are all true points. My dad spent 37 years as a New York State and Pennsylvania special education certified teacher in the public schools. And one thing, and it's just kind of thoughtful putting it out there, is some of it is on us as parents. There is a major discipline issue in the public schools, and some of it is probably of the public schools making, some of it is of the legal framework and just when it comes to kids and juvenile delinquents, but a lot of it is a lack of good old-fashioned parenting. And again, I think of Yuval Levin's book, Time to Build. I think of Alexis de Tocqueville, Democracy in America, about the importance of civic institutions. All of us have spheres of influence. And There is a major issue with just parents not being parents, not loving their kids enough to be able to set boundaries, and that's bleeding over into the public schools. We could get all the curriculum fixed, but if parents are not raising kids to be respectful of others, we're going to have major issues still.
Yeah. Earlier, Will, I asked about is there a limiting principle to opting out of specific, courses or classes or whatnot. Let's ask the same question, but more broadly. Is there a limiting principle that you would recognize for parental rights, or is it simply a case that the parent is always right and the school system is there to serve the parent's interests?
I've thought a lot about that, and there are two things. The first one is the president of HSLDA, Jim Mason, wrote about how parental rights are a fundamental right, but they are not an absolute right. And it's a very interesting distinction. Fundamental rights are the highest right in our constitutional legal system. Strict scrutiny, that's a legal term of the highest burdens that the government has to meet. But it's not an absolute right. And you can't abuse or neglect a child. Again, Melissa Moskela writes about this in To Whom Do Children Belong, that if parents act in a way against nature, harmful to their children, abusive to their children, and I think it's very important, and Melissa really said this very well at the last week's events at Heritage and Cato, in a non-ideological way, but if parents are acting in a way against nature, harmful to their children, then that's a limiting principle right then and there. We are not talking about absolute rights of parents to be able to abuse and neglect their children.
But to that end, we don't, the idea that we would make laws or have practices and procedures based on the worst component or the assumption, right, is a problem. And we don't do that in really any other area of American life, and it shouldn't happen here.
Certainly, there are unfit parents. We talked a lot in the last panel about the parental exclusion policies that are across the country. There are unfit parents out there. There are bad parents. But that is, even those parents deserve due process. And so every education official is a mandatory reporter. If you think a child is being abused, is being beaten, is in danger, you have to report that, to CPS. And so for a CPS process obviously is it is onerous, it is hard, it sucks. We have heard horror stories about that. But at the end of the day, you get to present evidence. They will interview your child. This is not just the math teacher saying, "Oh wow, look, Robert's a Christian. Robert's a Catholic. I think he's probably an unfit parent." They don't get to make that decision unilaterally behind your back. And I think that's where we have started to see this massive disconnect.
And in the situation in the Perez case in Florida, when there was a little girl who was being secretly transitioned, and she actually tried to take her own life while at school. And when the parents arrived and the girl was in the middle of being Baker Acted, the parents found out that in fact they had not been told about their daughter's want to change her gender because they were Catholic.
Well, when I first heard about these the secret transition policies as a former teacher, my immediate response was, well, hold on a second, because the justification you heard at the time was, well, the parent might not accept it, the parent could be a threat to the child. I'm a mandated reporter as a teacher. If I believe that the child is in danger from the parents, I don't have the choice, my hands are tied, I must report it. If that's not the case, then I don't have the right under FERPA to withhold that information from a parent. So either way, this is why I asked the question about FERPA. It just didn't make sense to me, because it feels like this has been settled, if not in law, then in educational practice.
One thing about FERPA really important, FERPA is basically a dead letter. It's the only way it can be enforced. There have been court cases that there is no private right of action, so you can't hire any of the fine lawyers here to enforce a FERPA violation. The only way it can be enforced is through the U.S. Department of Education, their Office of Civil Rights. And in 2010, U.S. Department of Education brought a FERPA challenge. I think it was University of Chicago, some blatant violations. They lost so badly that they have not brought, U.S. Department of Education has not brought a single FERPA challenge since 2010.
Although they are investigating Maine on those grounds right now.
I wish them luck.
So boom.
Maybe we'll do it.
Well, and you asked a question when we were preparing for this about policy changes that need to happen. The Pupil Protection Rights Amendment, which says children shouldn't be surveyed in school, Nikki and defending it have shown that there are crazy surveys happening in schools asking children all types of questions that federal law prohibits, FERPA as well, that there needs to be this private right of action, that it's the fox watching the hen house. When you have this type of a violation happening, what can you do about it? There's really nothing. You go to the people that are violating your your rights. You tell them you're violating my rights, and they say, oh, okay, and then they just keep go ahead and doing it because you just can't hold them accountable in any way. So my policy would be to make an amendment to PPRA to put in a private right of action.
You're anticipating my final question before we go to audience Q&A. And Tiffany, you were wondering if Randy Weingarten is watching. I have no idea, but it's AEI, so surely we have policymakers and lawmakers watching. So if you could speak directly to lawmakers, what is one policy change, and you can choose state, local, or federal level, that you believe would most honor the spirit of Pierce? It's your chance to give us a wish list.
You want me to start? I'll start. I guess my message to policymakers and elected officials is this. We currently have a system of government schools that are abusing the rights of parents and abusing our families. When you are a parent, you do everything you can to stop your children from having harm come to them. And I use this example a lot of a bike helmet. When you're a parent, you have your child wear a bike helmet. It's not because they've been hurt on a bike before. It's because you know that the potential is there for harm. When we have government entities that are placing children in harm's way, and we as citizens have no ability to stop that harm until it has occurred to our child, we have to let them be hurt. We are tearing apart American families and American society. The message that it is sending is that the government has an unbridled right to abuse American citizens. And so I just think, when you look at how we save our country and how you strengthen the will of the people, if parents don't have standing in courts to say, listen, there's this thing that's going to happen in school, I'm really worried about it. I know my child's vulnerable. And you're forcing parents to be complicit in that harm by sending them to that school. It has to stop, or else parents will lose their faith in our country, in our elected officials, in our leadership, and America won't survive.
My recommendation to policymakers would be at the state level, and it would be remove red tape and government entanglement on home education families. Currently, 12 states have no requirement that families check in with the government, give notice of intent, give documentation to the school district. They, of course, have to meet compulsory attendance laws, education neglect laws. They have to educate their children, but they don't need to seek the permission of the government to do it. Those other 38 states, these 12 states, by the way, are red and blue states. These other 38 states should lift these government red tape, make it free for homeschooling. It would benefit the public schools, less paperwork, less time away from educating public school students, and it would benefit homeschool families, and it would be in the vein and spirit of Pierce versus Society of Sisters.
I think, expanding school choice is a real key part of this because right now, they're able to squeeze the goose that lays the golden egg, and we just have to sit there and take it, like I said before. But if families are able to go find something that comports with their values, that they can afford, they will leave. They will find something that suits them better. Some people will choose to stay in their local public school for one reason or other. Other people will homeschool. Other people will go to a private school or a special needs school. But as of right now, too many people's hands are tied and they are trapped by boundaries, by other things. Even when we had sued Linn-Mar School District in Iowa a couple of years ago, that was a state that actually had open enrollment, but families said all the good districts around us are full, they're not taking anybody new. And so I think people are still too hidebound right now by the current system, and so passing ECCA I think is gonna go a long way, but that's a floor. I mean, that's a foot in the door, but let's keep going until everybody can actually obtain the education that they want.
Okay, there are microphones on the floor. Raise a hand and a microphone will find you. Jenny Gentles in the corner.
Yeah, I wanted to mention that the Department of Education has the Office of Student Privacy Policy, and I think it's an assistant division. And so if there are FERPA concerns, then parents should be reporting to that because that's going to be a much more active office now. It doesn't have to go to the Office of Civil Rights. It goes to that other office. And then I was wondering for the panelists how much you think that technology might be causing a problem in schools. And Robert, when you said that the curriculum transparency might cause a false sense of security, I wonder if the learning management systems, Canvas, Google Classroom, where parents think, I know what my children's assignments are because they can click around this complicated system and they might see a grade, but they actually don't get hard copies of materials. They don't see the whole packet anymore. It doesn't come home like it does in the traditional K-8 private school that my younger daughter is going to. So I'm wondering if there are other areas that we should be looking into, like the learning management systems that are actually putting up a barrier between parents that they might not even be thinking through.
It's a great question, and I don't have a good answer for you, and the obvious answers are unsatisfying for complicated reasons. In other words, you're not going to know everything that's going on in a child's classroom until or unless you've got cameras in every classroom. Do you want that? I'm not sure we do. But at the very least, using these management systems, I would argue that you need, I think I reflect on my own time as a teacher, minimum, because I didn't have a set curriculum, that's why I became a curriculum advocate. But even if I did, the only real way to know what the lesson content would be curriculum transparency at the lesson level. Because even when teachers use a set curriculum, they customize it, they differentiate instruction. They're doing that as a good practice. They're doing it in writing. They've got their, the teacher plan book, as it were. So I think you have to at least have the visibility at that level, at the lesson level, not at the curriculum level. I'm not sure if anybody else has thoughts.
Yeah, no, I think you're right. We got a FOIA a couple years ago from the Kirkwood School District in Missouri, and it was teachers saying, here's how you keep stuff off Canvas so that parents don't know, which I find creepy, I don't like. And so, yeah, I think that is fully part of it. So yes, you're right, Ginny.
So Robert mentioned cameras in classrooms. I don't know that I'm that upset about that idea, to be honest with you. During COVID, lots of school districts put cameras in classrooms on the teacher. There's this idea of taking phones out of schools. Anything that the teachers union support, I'm always kind of wary about because I really do. I know I sound like I'm very concerned about them. I am. And so this idea of, I don't believe that kids should be on the phones in the classrooms. But the problem is that the teacher doesn't have the authority to tell the kid to get off the phone. And that authority issue, that breakdown in the discipline in the classroom is the root issue that taking the phones away doesn't solve. And parents, and I know people don't like this argument because people like the idea of getting the phones out of the classrooms, but parents rightly are concerned about what is being taught in the classroom. And so I know you make the joke about the cameras, but parents are concerned about what's being taught, and the public school system and public teachers and the public teachers unions certainly have given them good reason to be concerned.
It's not a joke. I just think it would be I worry if the juice is worth the squeeze. But I'll meet you halfway.
Police have cameras on them.
Sure. Well, that's exactly right. And that anticipates the point I was going to make, which is when I said earlier that I didn't even hear the language of Pierce as a teacher until I had left the classroom. You know what else I never heard as a teacher? Hey, Pondiscio, you're a public servant. You're a government employee.
That's right.
You commented on ed schools before. This would be one. It's a cultural shift, I think, that is needed to change. In other words, I don't think I'm overstating this. I don't think the average teacher is encouraged to think of himself or herself as a government employee. Now, look, it's different being a teacher than working at motor vehicles or being a cop or a fireman. But at the end of the day, yeah, you're a state actor with tremendous influence over a captive audience of other people's children. So to answer my own question, what's one policy change? This isn't a policy change, it's a vibe shift, as the kids would say. Teachers need to be reminded early and often, you're a public employee, you're not a free agent.
And these aren't your kids.
And they're not, well, that one I'll defend to a certain degree because I kind of, as an elementary school teacher, it's benign most times when teachers say, my kids. We say it all the time. We don't mean it, but your point is...
But when you have the leader of the free world, Joe Biden, at the time standing in the Rose Garden on Teacher Appreciation Day saying to the teachers, when the kids are in your classroom, they're like your children.
Yeah, no.
So you have the leader of our country saying that message that it sends across the country is a violation of parental rights. And I'll just say this, I am so thankful for President Trump. The first time I ever spoke with him about parental rights and what was happening in the schools, he was shocked. He said, I don't understand. I think he said it when I interviewed him. It's like they don't even like the kids. It's like they don't even like the parents. He can't believe that it's happening. And I think that's where the majority of Americans are. They're kind of trapped between this idea, this is absolutely awful and it can't possibly be happening, right? And we're finally reaching this point. And again, I'll give Nikki a lot of credit and the parents across the country that have been showing the issues that we're finally getting to like a point of American people going, oh, wait, this is happening. And this is not just happening to someone else. Now it's happening to me. And that's certainly driving people to action.
So as someone who files FOIAs, I like that teachers often forget that they are public employees. They put a lot in writing. But that being said, right, let's I know it's a panel about Pierce, but also like, I mean, Garcetti comes to mind. Yeah. You don't have unfettered rights in the course of your job, speech rights in the course of your job. Like you don't get to just pop off about all things that like you have thoughts on, just because like I don't want a physics teacher talking about abortion, like things like that. And people, I think teachers often forget that like they have a lane and they're supposed to stay in that lane.
Well, this is where I like cameras in the classroom, because as a teacher, more than once I've had words that I've said played back to me in a different context by a parent. Like, wait a minute, those were the words that I said, but you're missing some key context. It would have been great to say, let's go to the videotape. Forgive me, I can't see in the bright lights, but there we go in the back.
Hi, thank you for your time. I have a question regarding teachers' unions. So we see that unions not only have an influence in the classroom, but they also influence state budget spendings. Is there any legal strategy or policy recommendations to reduce the power of teacher unions at the state level?
Yeah, Florida's done some really great things as far as restricting the rights of teachers. They said that over 60% of teachers in the union had to be dues-paying members, or else the teachers union would not be certified anymore. And we've seen that I've seen a couple of things. We've seen some of the districts fudging some of the numbers, but we're seeing that some of the unions are not certified anymore to be able to continue. The other thing that we did that was really wonderful was that the district used to deduct the teachers union's pay from the paycheck before they gave it to the teacher. And it's really different when you have to actually write your own check, right? When you get the money and then you're like, do I want to actually send this money over to the teachers union? And so we've really seen that have a huge effect. And again, I want teachers to keep the money in their pockets. I think we underpay teachers. I think they have one of the most important jobs in the entire country. Without saving education, we will not save our country. We can close the border, we can work on the economy, we can do all these things, but ultimately, you know, kids are the future of America. And so those are two really great things that states can do in order to reduce the power of the teachers union.
It is also worth noting that after Janus, there was a very conscious decision on the behalf of the teachers unions to run people in school board elections as well. And so they're still able to get a lot of their things done, signing these like bullshit contracts. Sorry, I'm not supposed to swear, my bad. But you know, but where it's like, you know, it's just so contracts that are really wackadoo are making their way through because they have a majority in the school board. And that's why groups like Moms for Liberty and 1776 PAC that are encouraging people to run are so crucial, because at the end of the day, it is like, I mean, there is trench warfare taking place at the local level as well as at the state level and the federal level.
Well, and school choice defangs teachers' unions as well. In 15 states now, you've got educational savings accounts, which functionally allow parents to take the lion's share of the state money, opt their kids out of the public school, and educate their kids independently.
So let's close that loop. So the teachers' unions, 99% of the contributions, political contributions the teachers' unions make, go to Democrats. Democrats are always the ones fighting against school choice. It's because they want the money from the teachers' unions and the support. And Corey DeAngelis, our very good friend, will always come and say, he's like, oh, look, another Democrat who doesn't support school choice but sends their kids to private school. It's like without fail now that we see that time and time and time again. And so I just think we have to really, you know, be honest about the teachers' unions, what their purpose is, that they are a political organization that is meant to change the fabric of our country. You know, we need to support teachers directly and again, get them out of the unions.
Okay, we've got time for one more question, and if there isn't one, then I've got one. Can't see. Okay, well then, all right. A practical question for parents who are listening to this conversation, who feel their rights are being sidelined in their child's education. What advice would you give to parents as closing thoughts?
Contact Nikki and Tiffany.
The most important relationship that you have as a parent is with your child's teacher. And so I would just say, from the very first day of school, really work to build a relationship with the teacher, ask them a lot of questions. If there are topics that you're concerned about that they might be introducing into the classroom, ask them very directly. Will you be talking about this? If so, when will you be talking about it? How will you be talking about it? And just make sure that they know that you are involved and engaged in your kids' lives, that you're not going anywhere, and that you're going to be all up in their business all the time.
I talk in war metaphors all the time, so this is actually going to surprise you. But yeah, like I totally, like, I think it is that not everybody in the school system is a bad person. Like, not, right, there are a lot of teachers and administrators that are there, right, they're bullied by their colleagues. We have seen so many examples of like one bad apple spoiling the barrel, bullying their colleagues. And so yeah, it is like that, like, start low, like you don't have to go straight to a federal lawsuit, like talk to your teacher, like, where did this come from? And, you know, we have found out in talking to teachers, you know, I was really tired. Like I was just looking for an assignment for like, this XYZ week or like this lesson plan. And I just pulled something off and like, I didn't actually think it would piss people off. And so I think there's like a non-zero amount of ignorance. And so to work your way up, but then also don't stop. If you don't get the answer you want from your teacher, go to the principal. If you don't get that answer, go to the superintendent. If you don't get that answer, then go to the school board. I mean, even, school boards often think that they work for the superintendent. They don't, right? And so just a fundamental misunderstanding of the system in and of itself, I think that's really important. That also, and then it's like when you see at the airport, see something, say something, like don't just allow it to happen, like flag it for somebody, like tell someone so that something can happen and we can change it.
Will, any final thoughts?
I think it's just important. Remember Pierce versus Society of Sisters, that the child is not the mere creature of the state. And whether it's in public, private, homeschool, medical decisions, you need to be your best advocate for your own children.
And I would just go one step further on that, regardless of what the Supreme Court says. You have a natural right given to you by God to direct the upbringing of your children. You have a duty to do that. There's only, God commands you to obey him, and then he commands children to obey parents. It's a very special relationship, and no government has the right to take that away.
And with that, we will close. Please join me in thanking Tiffany Justice, Will Estrada, and Nikki Niley.